Good evening. My name is Isabelle Teare with the WTJX NewsFeed, and this is Trial Watch. Today was the fourth day of the case, the United States of America versus Ray Martinez and Jenifer O'Neill. And we started this morning before the jury came in, dealing with a motion that the United States filed over the weekend. This motion was to limit certain arguments by Ray Martinez's defense attorneys. And before I get into that, I'm just going to give a little background so everyone can understand. Anyone who's been following this trial will remember that the defense has asked a lot of questions of both the witnesses, Lisa Alejandro, the commissioner for the Department of Property and Procurement, and also David Whitaker, about whether any other company in the Virgin Islands would have been able to provide the services that Monethos was providing in this contract they had with the Virgin Islands Police Department. Okay, so in their motion, the United States said that the defense was trying to introduce the idea that this contract with Monethos would have been signed regardless of anything because Monethos was the only provider. And they said their issue with this argument was, and this is from their motion, that it is no defense to bribery that a defendant received a bribe for something the defendant would have agreed to do even without the bribe. So the judge heard, some oral arguments on this morning and said to the attorneys that the idea isn't whether whether this contract was beneficial to the United States Virgin Islands. The idea and the thing being talked about is whether those services were provided via bribery. He told the defense that they can't say this was the best deal for the United States, and that's their defense. They can't use that as a defense. He said, and he ended up ruling that for the purposes of today, the idea that the contract was good for the Virgin Islands and therefore anyone would have signed it just was not allowed. Miguel Oppenheimer, the attorney for Ray Martinez, understood and said the only questions he would ask was whether Monethos was able to fulfill what was in that contract. So after that, the jury was brought back in, and we went right back to Ray Martinez's attorney's cross-examination of David Whitaker. Now, before, on Friday, before we all left for the weekend, the defense had left off by talking about when Whitaker became a cooperating witness with the FBI. And Oppenheimer asked Whitaker if he was aware that from the time he began cooperating with the FBI in September of 2023 to, when the phones were seized in June of 2024, was he aware that in that time period, the FBI recorded over 7,400 calls on Whitaker's phone? Whitaker said, he wasn't surprised by that number, but he wasn't aware of the actual number. And it's just important to mention that because we've heard and hours of recordings of phone calls and meetings. And what this really shows is that was just the tip of the iceberg. Anything that happened on David Whitaker's phone in that time period was, recorded by the FBI. So then we moved into the defense asking Whitaker about this 2008 conviction in Rhode Island. He said, in Rhode Island, you pled guilty to wire fraud, didn't you? Whitaker said, yes. Then Oppenheimer asked, and you were facing a potential imprisonment of over 60 years, at which point Alex Dempsey for the United States objected. Now, quick side note, this is the big tension point in this case for the defense. This was what was discussed on the first day of the trial before jury selection even began. This is about what is allowed to be brought into the trial, what the jury is allowed to hear about Whitaker's criminal history. And anyone who has been following will remember that while the judge allowed certain questions about that 2008 Rhode Island conviction, he said it was a very limited scope of questions that could be asked. So keep that in mind as we move forward. So Oppenheimer then asked Whitaker if he cooperated with the federal government in that 2008 case. Whitaker said yes. Then he asked, well, wasn't your cooperation related to charges, or excuse me, he said, but your cooperation was not related to the Rhode Island charges. At which point Dempsey objected again. And the judge intervened here and he told the defense, this is beyond the scope of the ruling I gave you. Keep that in mind. Oppenheimer then asked, you remember being sentenced? And do you remember your sentencing hearing? Dempsey then objected again. And the judge again spoke and said that to the defense, you have a very limited scope on this conviction questioning. Then Oppenheimer asked, was the judge informed of your cooperation at your sentencing hearing for this, Rhode Island conviction? Dempsey objected again. So just really showing that tension between the United States and the defense. The defense is trying to open a door to allow for more questioning. The United States is trying to keep that door very much so closed. But we did see a document, a piece of evidence that the judge allowed to be brought in. And this was the judgment conviction order from that 2008 Rhode Island conviction. And the title of the case was the United States of America versus David Whitaker, AKA David Andrews Chase. And on that document, we saw that he had pled guilty. This is David Whitaker, had pled guilty to wire fraud, conspiracy to defraud the United States, and commercial bribery. Then Oppenheimer asked Whitaker if he was aware of the criminal monetary penalty associated with this. And the document showed that the restitution owed for this was a little over $10 million for this crime. Whitaker said that all of this sounded familiar, but he couldn't fully remember. He said he'd never seen the document that we were being showed. And he said, but if we're relying on this document, yes, he is aware that it was over $10 million. Then Miguel Oppenheimer moved on to asking him questions about the stakeout agreement. He said, during your meetings with the FBI, isn't it true that you told them that Joseph Bolero, this attorney that Whitaker said was, a friend and someone who he had worked with for a long time, isn't it true that you told the FBI that Joseph Bolero advised you about this stakeout agreement? Whitaker said yes. Oppenheimer then said, are you aware that the FBI makes makes reports of all of these meetings that they have? And Whitaker said yes. However, he'd never seen copies of these reports the FBI made. Then there was some discussion about whether or not Whitaker remembered telling the FBI that Bolero, this attorney, had apparently told him as long as Whitaker didn't benefit financially from helping Ray Martinez and that the money generated went back to Whitaker, that Whitaker would be okay. This was kind of a confusing moment of cross-examination because Whitaker was saying he doesn't remember, saying that. And he said that if that was on the FBI report, maybe he had misspoken, that kind of idea. We then moved on to Oppenheimer asking Whitaker about invoices submitted to Sandra Webster at the Virgin Islands Police Department, the financial division. Whitaker said that the majority of the invoices he submitted went to Ray Martinez. Oppenheimer made the point that they also went to the financial division, and which was run by Sandra Webster, which Whitaker said, yes, correct. Then this is just a moment where Oppenheimer asked Whitaker if he remembered in November of 2022 that Monethos purchased equipment from KLS. And Whitaker said no, he didn't remember it. For anyone watching, this was kind of an interesting moment because anyone who lives, in the Virgin Islands will remember that KLS is not the name. It's KLR Services. That's the kitchen supply store. So Whitaker said no, he didn't know anything about KLS. I saw Ray Martinez whisper to his other attorney at this point, who then, spoke to Miguel Oppenheimer. Oppenheimer then, rephrased the question and all of his questioning to say KLR. But that was an interesting moment about, okay, if the name had been wrong and he had said no, he hadn't heard about that, Whitaker wouldn't have technically been lying because it was KLS, not KLR. Then the defense went into bringing up numerous bank statements from Monethos, and they kept asking David Whitaker to say, okay, on this statement, how much was credited, how much was debited. This went on for multiple statements over multiple months, then asking Whitaker what certain wires were for. Whitaker said he couldn't recall off the top of his head because those wires just said an amount and then wire. As I said, this went on for a while, and I'm not sure what the defense was trying to open here. What point they were trying to make or unlock. Then after that, Oppenheimer asked if Whitaker was the owner of Monethos until April of 2024. Whitaker said yes, he was. Oppenheimer asked if he sold it to a new owner. Whitaker said yes. And Oppenheimer said it was a former employee, wasn't it? At which point Alexander Dempsey objected, and we didn't get any more on that questioning. Then it was time for a short break. And this was interesting because Whitaker's testimony is not over. The cross-examination by the defense is not done. However, the United States called in a new witness. And this was because this next witness had upcoming travel plans that couldn't be moved. And so she had to be fit in this morning. So we took a break from Whitaker, but we're going to hear from him again. The United States called their witness. Her name is Jasmine Blyden. And the federal prosecutor, Charisse Amaro, did the direct examination here. And Jasmine Blyden said that she was a cleaner for a living and that she had met Ray Martinez when she was working at Bluebeard's Castle. She said she'd known him for over 20 years and that they had had a really good friendship, but they now no longer had any relationship. And Blyden was giving very short, succinct, quick answers. Very quick, abrupt almost. And her testimony lasted all of, maybe 5 minutes. She said that on June 13th of 2024, she was contacted by Ray Martinez via telephone, and he asked her if he could stop by her home in Estate 22 to use her laptop. She said yes, he came over and that he used it at her dining room table. She says at this point she was in the kitchen, she was making food, and she couldn't see what he was doing on the laptop. She said he spent about 15 to 20 minutes on her laptop. Charisse Amaro then asked her if she had asked Martinez what he was using the laptop for. Jasmine Blyden said no, she didn't remember. Amaro asked, did he tell you? She said no. Amaro asked, did he save anything on your computer? And she said no. She said she actually went on the laptop after Martinez had left to see if he had saved anything and that she didn't see anything. Then it was the cross-examination of Miguel Oppenheimer, the attorney for Ray Martinez. And Oppenheimer asked if Ray Martinez had printed anything from the laptop. Jasmine Blyden said no. Oppenheimer then asked her if she was a computer specialist. She said no. Oppenheimer asked if the FBI had searched the laptop, and she said yes. And he said, are you aware if they found anything? She said no. Then Oppenheimer asked how long the FBI examined the laptop for, and Jasmine Blyden said she thought it was about an hour. Then Charisse Amaro did a quick redirect. She said, when Ray Martinez used the laptop, was there a capacity to print? Blyden said no, there wasn't. The laptop was old and it couldn't connect to the printer. Then Oppenheimer did one more question on recross, said, do you own a printer? And Blyden said yes, she did. Now, this was kind of an interesting witness because what this witness is about, what we believe this is all about is that promissory note that the United States says Martinez wrote in his attempt to cover up the true nature of all of these payments between Whitaker, Monethos, and himself. But the word promissory note wasn't used. That wasn't discussed, but we're likely going to hear about that down the line. Then it was back to David Whitaker. Jasmine Blyden was dismissed. Whitaker came back on the stand. And we're now to Dale Lionel Smith's cross-examination of Whitaker. Dale Lionel Smith is the attorney for Jenifer O'Neill. And, right off the bat, we are back to this tension of defense trying to introduce something, United States objecting. Smith asked, "Isn't it true that you cooperated on a Google case?" Alex Dempsey objected. Smith said, "Isn't it true that you participated in an undercover case?" Alex Dempsey objected. Smith then asked, "When you moved down to the Virgin Islands, you framed yourself as a forensic specialist, didn't you?" Whitaker said, "I wouldn't say it that way." Smith then says, "Well, you got government contracts by claiming expertise in this area, in those areas, didn't you?" Whitaker said, "Yes." Then Smith asked if the Virgin Islands Police Department gave Whitaker something called a gray key to gain access to phones. Whitaker said, "Correct." Let me just catch up here quickly. Lionel Smith then asked Whitaker, "As you worked for the government and had discussions with all of these law enforcement officials, in this capacity as kind of an expert working for them, did it occur to you to inform them that you were a multiple times convicted felon? Did you tell them about your history as a felon?" And Whitaker said, yes, he did. When asked which, government officials he said he told Timothy Perry and Quincy McCrae. Timothy Perry works as the chief of the St. Thomas Criminal Division for the Department of Justice. Smith then asked Whitaker, "So you have multiple felony convictions?" Whitaker said, yes. Smith then says, "And all of these involve, deceit and lies and stealing?" Whitaker said, yes. Smith then says, do you remember a conviction with a restitution for more than $10 million? And Whitaker said, "This is not what I understand it to be currently." And Smith said, "But it started that way." And Whitaker said, yes. And then Smith said, "In 2025, you still owe," but he didn't get to finish his sentence because Alex Dempsey objected. And the judge came in again at this point and, looked at Smith and said, "Counsel, you have been admonished. You have been advised not to say that." And just said, "Do not violate my court order." This was a kind of a heated cross at a lot of moments between the judge and Dale Lionel Smith. It was obvious that the judge was getting very frustrated multiple times with Dale Lionel Smith. Then Smith moved on to questioning Whitaker about these listening devices that Whitaker has said he planted in government offices. Smith said, "You planted all of these yourself?" And Whitaker said he did not plant all of them. Smith then said, "But isn't it true that in an FBI report, you told them that they were all purchased from the same location?" At which point Alex Dempsey objected. Smith then went back to talking about Whitaker's past convictions, this time the things he's pled guilty to in the U.S. Virgin Islands. Smith said, "Isn't it true that your recent convictions involved deceit and fraud?" Whitaker said, yes. And Smith then said, "Wasn't it true that you told the FBI that planting all of these devices was Martinez's idea?" Whitaker said, yes. Then there was some questioning that I'm not going to get into because it didn't really go anywhere. But Smith did look at Whitaker and say, "You are aware that your plea agreement with the government states that you understand you have to be truthful in your answers. Whitaker said yes, and Lionel Smith said, even though you are aware those answers help O'Neill. Whitaker said yes, he was aware he had to be truthful no matter what. Then Smith started asking Whitaker about whether or not the FBI told him what he could and could not do during these recorded conversations. He said, did the FBI have discussions telling you that you cannot entrap people? Whitaker said, the FBI never asked me to entrap people. Smith said, that's not what you're being asked, sir. At which point Whitaker said, I did not entrap anyone. I'm confused by your questions. Lionel Smith said, wasn't it true that there was a time you tried to approach Jenifer O'Neill and record her and the FBI admonished you not to do so? Whitaker said he didn't recall. Then Smith started asking him about why it was that during the tapes, the recorded conversations we've heard in this trial so far, why is it that we haven't heard anything about the subject of, planting these devices? And Whitaker said that it just wasn't something discussed on those tapes. Whitaker said that he would have conversations with the FBI before or after the conversations or interactions that he taped with Jenifer O'Neill and Ray Martinez. And he said that on one occasion, he wanted to bring up the listening devices, but the FBI told him to hold off on that. So Lionel Smith then said, so it was true that you met with the FBI before going out and capturing these recordings? Whitaker said yes. And then this was kind of the big moment of today. Lionel Smith said, isn't it true that in September of 2023, you told the FBI that the governor of the Virgin Islands takes bribes? Whitaker began to ask what date, at which point Alex Dempsey objected. Then Lionel Smith moved on to asking other questions. He said, isn't it true that in September of 2023, you spoke with the FBI about cooperating? And isn't it true that one of the things you said was that the governor of the Virgin Islands was corrupt? Whitaker said, I don't recall. I might have. Smith then asked, isn't it true that you told the FBI that everyone in the Virgin Islands government is corrupt? Whitaker said, I might have. Smith then said, isn't it true that you told the FBI the only person who was not corrupt was Anthony Thomas? Whitaker said, I can't recall. Then Smith moved on to asking Whitaker questions about the press conference that Martinez had when they announced that they had found these listening devices. Smith said, when that news broke, isn't it true that Ray Martinez had a press conference and that you brought a reporter from the news site that Whitaker ran called USVI News, and that you did that because you were trying to control the narrative about how this story would come out? Whitaker said yes. Smith then said, did the USVI News publish a story about the press conference with Jenifer O'Neill's name? Whitaker said yes. Smith said, was it true that you had a discussion with Jenifer O'Neill after, and wasn't she angry about what was said in that story? Whitaker said yes. Smith then said, did you leave that conversation with Jenifer O'Neill with the understanding that the things attributed to her in that story were untrue? Whitaker said, I don't know how to answer that question. Smith then moved on to asking Whitaker questions about the inflated invoices that we've heard about. He asked Whitaker, why didn't you say to Jenifer O'Neill that you wanted to fraudulently inflate the invoice? Whitaker said, I believe I did. Smith said, did you use the word fraudulently? And then Whitaker said, I don't recall. And then Whitaker went on to explain, when asked more about why he may not have used the word fraudulently specifically in his conversations with O'Neill, Whitaker said, you don't say, let's commit fraud. You say, let's put this line item on this invoice here so we can buy this other thing. Whitaker said, well, weren't you inviting O'Neill to commit a crime to capture it on a recording? Whitaker said, no, that's not what he was doing. Smith then asked, well, you told the FBI that everyone in the Virgin Islands government, from the governor all the way down, is corrupt. Whitaker said, generally speaking. Smith said, you did this because you didn't want to go to jail. Isn't that true? Alex Dempsey then objected. Smith said, let me just read this. Sorry, one moment. Oh, Dale Lionel Smith then asked, isn't it true that it's your understanding that the more you cooperate, the more people you get for the FBI, the less time you'll get and a better plea? Whitaker said, no, that's not what they've told me. Then there was a lot more questions by Dale Lionel Smith, and there were multiple times where Whitaker basically just said, I need you to rephrase that question. This was because a lot of Smith's questions kind of were multi-part or honestly just a little confusing to understand, even as someone in the gallery, at which point the judge told him that he needed to, rephrase his questions, ask certain questions without loading them, he called it. Then there was kind of a moment of contention between Dale Lionel Smith and David Whitaker. Smith was asking him about things he had said to the FBI about planting these devices. And Whitaker was kind of saying, I don't recall. At which point Smith said, when you testified earlier for the United States, you didn't answer, don't recall to their questions, did you? And Whitaker said he thought he had. Smith then asked him how many hours he had spent rehearsing for this trial with the government. Whitaker said about 1 hour, that he had arrived the day before the trial, and that evening they had talked in this district court building for what he said was not very long, maybe an hour. Then Smith said, isn't it true that you lied to Jenifer O'Neill and didn't make her aware of this scheme between you and Ray Martinez? Alex Dempsey objected. And the judge once again told Smith to break down his questions. He said, you're asking, too many questions in one. So more questions from Smith asking, isn't it true that you never told Jenifer O'Neill that it was a fabrication that you had planted all of these devices? Whitaker said he had not told her at the time that he had planted those devices. Then Smith asked, when talking to O'Neill about the deposit for her coffee shop, isn't it true that you said this money was coming from Ray Martinez? Whitaker said yes. And Smith said, and you never changed that and told her it was coming from elsewhere, did you? And he said, no, he hadn't. So then Smith again said, so you never told her about your criminal conspiracy with Ray Martinez? And Whitaker said he did tell her. He said that they had talked about hiding funds. At this point, the judge intervened, and this was because Smith had been asking those long questions again. And the judge just looked at Smith and said, you need to stop giving speeches. Basically saying, Smith, you need to ask a question. You can't say everything that you want and then, try to tack a question on the end there. More questions were asked. Alex Dempsey was objecting. It was kind of messy here for a bit. Then Whitaker, here's just another example. Smith asked Whitaker a question. Whitaker said, can you ask that again? And Smith looked right at Whitaker and said, stop trying to avoid my questions. At which point Alex Dempsey objected, and the judge got a little heated, said, you cannot do that to Dale Lionel Smith. He said, you cannot do that. You know that. You are an experienced trial attorney, and really just, shut all of this down. Okay, then we took a break for lunch. When we came back from lunch, there was a discussion between the attorneys and the judge that happened outside the presence of the jury. And this was Alex Dempsey saying that he was going to make an oral motion to limit questioning from Dale Lionel Smith over all of this kind of drama, for lack of a better word, that we saw unfold. But then it turned out that Smith was actually resting his cross-examination, so this wasn't an issue after that. The U.S. Did a quick redirect to Whitaker and asked him about this stakeout agreement. They said, was the stakeout agreement real? Whitaker said, no, it wasn't. When asked if they had taken steps to make the stakeout agreement a reality, Whitaker said, no, it wasn't. Going back to Ray Martinez's attorney's argument in their cross-examination, where they were trying to say that the stakeout agreement was a legitimate contract. Then there was a re-cross-examination of Whitaker by Dale Lionel Smith. He said, remember the questions I asked you earlier about your statement to the FBI that the governor is corrupt, that everyone except Anthony Thomas is corrupt? And Whitaker said he remembered Smith's questions and that he remembered general statements, that he made some general statements to the FBI. Smith said, isn't it true? Smith then asked him, sorry, let me just read my notes here. Handwriting's a little confusing. Oh, Smith then asked Whitaker, isn't it true that the payment that you received at Monethos, that it was authorized by the same government officials you say are corrupt? And Whitaker said that he couldn't say unless he saw what document Smith was referring to and what government officials. Smith then asked if at the time of the VIPD contract with Monethos being signed, if Jenifer O'Neill was aware of his history and his past convictions. Whitaker said, yes, she was. Smith then says when there is a contract and an invoice has to be increased, that doesn't necessarily mean fraud is being committed, right? Whitaker said, correct. That doesn't necessarily mean fraud is being committed. Whew, okay, and this was the end of David Whitaker's testimony, period. He left the witness stand. We won't hear anything more from him. And this was, he was the main witness for the government. He was the bulk of this case. So after Whitaker was dismissed, the United States called up their next witness. His name was Saul Lopez. He's the same person who actually testified in the Calvert White trial, for anyone who followed that. And he works for the FBI as a digital forensic examiner. He's part of their computer analysis and response team. That's called CART. I'm not going to go too into his testimony. Basically, what you need to understand is that he testified he was assigned to extract information from mobile devices, and there were search warrants for certain iCloud accounts that he extracted, and that he would then, extract this, upload this to a secure place, and then that data and all of that would be available to the FBI case agent in a readable format. And that was the end of his testimony. The United States then called up their next witness. His name was Miguel Moya. He is the senior vice president in charge of technology for First Bank. Once again, not going to go into everything from his testimony. What you need to understand is that he testified that First Bank doesn't have any servers located in the U.S. Virgin Islands, and that any wire transaction involving First Bank has to go through their servers in Puerto Rico. So he said, even if a wire was initiated in the Virgin Islands, it would have had to gone to Puerto Rico, the data center there, in order to happen. And now, just something I observed quickly, stepping back, looking at the courtroom more generally. Throughout this, I was looking up and trying to, look at the jury, see if I was getting any reactions from them, any insight on that. And, I really don't have anything for you on that. They were, for the most part, just very, very focused, not very expressive, looking along at the screens in front of them where evidence was being presented, or, up at the witness stand where someone was testifying. The United States then called their next witness. His name is Jason Marsh, and he is the Deputy Commissioner for Professional Standards for the Virgin Islands Police Department. He's been in that role for the last 9 years. And Dempsey for the United States asked him if in this role, if he had any role in approving invoices. Marsh said yes, that he did for the independent monitoring team. This is the team that oversees the consent decree for the Virgin Islands Police Department. And Dempsey then asked Marsh if he would ever sign invoices that were not for teams that he oversaw. And Marsh said yes, he would sometimes sign other invoices on the occasions when he was acting commissioner for the Virgin Islands Police Department, when both the commissioner and the assistant commissioner were not in the territory. And so he said that in October of 2023, for about a week, he was serving as acting commissioner, and he in that week signed an invoice for Mon Ethos. He said the invoice was emailed to him by the VIPD CFO, Sandra Webster. He said that he didn't review it the way he would have reviewed invoices related to his specific duties and team, because he said when it had come from the fiscal department already, it had been reviewed by others, and he assumed it had been reviewed by the fiscal team. So by the time it was coming for that signature, it had already been approved. Marsh then said that he had was questioned a bit about his interviews with the FBI. And he said that, in these interviews, he had told the FBI that he was not close personal friends with Ray Martinez, but that, he did work under Ray Martinez and they had a friendly working relationship. He said that he also told the FBI that Martinez was what he called a hands-on commissioner. He said that he got involved a lot in the day-to-day operations and was, out on the street. Alex Dempsey, in his did then ask more questions and just asked Marsh that if he was aware that bribery was a crime. Marsh said, yes, he was aware. Dempsey said, would you ever sign an invoice that was the result of a criminal activity? Marsh said no, because it was a crime. That was illegal. And this was the end of Jason Marsh's testimony. The United States then called their next witness, and this was the final witness we heard from today. That witness was Charlie Irons. On the stand, he said his name was Charles Irons, but we've heard him referred to as Charlie throughout the case. And he is the general manager of Yacht Haven Grand. He has been the general manager for 13 years, he said, and his duties are really overseeing leasing and payments and everything having to do with tenant relations. He testified that Mon Ethos was a tenant at Yacht Haven Grand, and he said he was familiar with David Whitaker because David Whitaker, owned Mon Ethos and had signed the lease. He also said that he was familiar with Java Grand, and he was familiar with Jenifer O'Neill. Of course, Java Grand is that coffee shop in Yacht Haven that we've heard about throughout this trial. Irons said that in April of 2024, there was a deposit owed for the Java Grand lease. He said that tenants have to pay deposits to secure their space. And when Alex Dempsey asked if he received a deposit for Java Grand, he said yes, he had. And Dempsey then asked who had made the payment. He said David Whitaker. This is something we've already heard. We saw that exhibit that has already been brought up in the trial. That's the First Bank wire confirmation from Mon Ethos to Yacht Haven Grand, and from David Whitaker. And in the memo line on that wire confirmation, it says payment for Jenifer O'Neill lease for Yacht Haven Grand required lease deposits and payments by David Whitaker. The wire was sent on April 15th of 2024 for the amount of $17,730. Dempsey then asked Irons if he was aware of a connection between David Whitaker and Java Grand. Irons says he wasn't sure he would say he was aware of a connection. He said he thought it was odd, so he sent a text to David Whitaker to clarify and make sure that this was correct when that wire came through. He said that it was weird to him to see this because it wasn't normal to receive payments for a tenant from another tenant. Then Dempsey asked if he had received communications with Java Grand or David Whitaker about who would make this payment, before that wire came through. Irons said he didn't recall. Then there was the cross-examination by Dale Lionel Smith. Irons again said this was odd, but Smith said, but the payment was not for Jenifer O'Neill. It was for Java Grand, wasn't it? Irons said, correct. Smith said, and wasn't this even more odd because David Whitaker and Mon Ethos Pro Support hadn't paid their own rent at Yacht Haven Grand? Irons said that, yes, they had back rent that was due. Mon Ethos did. Smith then said, so did your company evict David Whitaker? At which point Alex Dempsey objected. Smith then asked, did you ever get additional rent from David Whitaker for Mon Ethos Pro Support after that deposit came through for the Java Grand lease? Irons said he didn't recall. Smith then asked, is Java Grand still a tenant? Irons said yes. Smith then asked, is Mon Ethos still a tenant? And Alex Dempsey objected to that question and it wasn't answered. Dempsey then did redirect very briefly, only asked one question. He said, who runs Java Grand? And Charlie Irons said, Jenifer O'Neill. This was the end of Charlie Irons' testimony. There was no cross by the attorneys for Ray Martinez. And so when Irons stepped down today, that was the end of the day. We actually ended a little bit early today because the prosecution didn't want to introduce their next witness when we would have to break so quickly after and interrupt that. So the jury was excused and the judge said that we were going to pick up with the trial tomorrow at 8:30 a.m., where we are expecting to hear from the next witness for the United States. And we're not sure who that is yet, but we also did hear today, the judge told the jury that he was hoping that the case would be turned over to them for deliberation on Thursday, which means that, the prosecution would have to rest their case and we'd hear closing arguments, either on or before Thursday. So that was the end of the day today. That is where we left off. I will be back in court tomorrow, and then I will be back here tomorrow evening for another edition of Trial Watch. I hope to see you then. Please tune in. Thank you for being with us tonight. Again, my name is Isabelle Teare with the WTJX Newsfeed, and this is Trial Watch. Have a good evening.